Good evening. This is John Milburn for Laws 12062 Alternative Dispute Resolution. We're into week 8. The material that we're covering at the moment is a little further back in the curriculum. We're still dealing with the matters to do with arbitration. Now, we have a number of people joining us this evening live. Thank you very much for doing so. I encourage you to ask questions, make comments, unmute your microphone, use the chat facility if you wish. And I think it's a fair assumption that those that are joining me live have already uploaded their first assessment, and thank you for doing so. If you're watching this as a recorded session, hopefully you've now uploaded your first assessment, and I hope to have the results to you within the next 10 days. And that will be the first and substantial assessment, 40%. All right, so arbitration. Last week we were talking about the ability to delegate to some degree arbitrators' powers, but only if authorised under the agreement. But ultimately the arbitrator must come to his or her own opinion in relation to matters under dispute. We also talked about the arbitrator's powers, and we discussed issues to do with adjournments. We were touching also on the issue of subpoenas and the fact that courts can issue subpoenas. Now, the decision that an arbitrator makes is an award. We know that. And it is effectively a decision which is binding on the parties. However, it can still be attacked, if you like, through process via court proceedings. And the basis upon which a court might decide to challenge an arbitrator's award would be, for example, if the award was made too widely. It went beyond the jurisdiction, or indeed there may not be any jurisdiction for the arbitrator to make the award at all. Also, it may be privileged. Now, if you're following along, I'd encourage you to look at the Act, the legislation as we proceed, the Commercial Arbitration Act, and I'll refer you to some cases. The first case is one from the Court of Appeal this year. It's Mango Boulevard, Pty Ltd, against Mio Art Pty Ltd. It was 2018, QCA 39. Sorry to give you the unauthorised report. Now, this is an issue involving remitting or setting aside an arbitration award on the basis of denial of natural justice. In this case, there was an argument about an arbitral award to be set aside on the ground that the arbitrator failed to afford the appellant procedural fairness. Now, we understand from that already that although the arbitrator has wide power and can make an award that is binding on the parties, the arbitrator has, if you like, a court-like function to ensure that the work that they do is consistent with appropriate rules of law. And one of those is procedural fairness, natural justice. In that case, McMurdo JA, Fraser JA agreeing, observed that procedural fairness is not an express ground to set aside an arbitral award under Section 34 of the Commercial Arbitration Act 2013. And in that sense, this case is therefore novel. So the Act, however, does require parties to engage and the arbitrator to engage in a manner that is fair to do so. So the observations of the court were that under the legislation, there was an argument about the reasoning being inconsistent with the requirements of a particular share sale agreement. It contained a formula, and there was some issues to do with what had been earlier decided in the matter. So I'm going to invite you just to read through that decision. Ultimately, the court decided that the appellant was able to present its case. No ground was established and the appeal was dismissed. But the reasons why it was dismissed may be relevant for the circumstances in terms of whether the arbitrator has decided according to law. Now, speaking of that, have a look at Section 21, Subsection 1 of the Act, and it talks about deciding according to law. But the question is, but what law? For example, it may be that we're dealing with an interstate matter. And have a look at the notes on section 22.2, and I'm just calling up the legislation as we proceed as well. So it says, failing agreement referred to in subsection 1, the subsection 22.2 provides for, 21.1, sorry, my apologies. I'm just going to go back to section 21. Yep. Okay, so have a look at section 21 of the legislation in that regard. My apologies. I'll start moving more efficiently through. Now, have a look at the provisions relating to arbitral proceedings, which is part 5 of the Act. Sections 18 to 27 deal with the issue of how arbitral proceedings are to be conducted. Now, there's some important points here, and one that we get from the case, the Court of Appeal decision, Mio Art, that I mentioned earlier, is the way in which the arbitrator deals with the parties. One of the keys is to treat the parties equally and fairly. Yes, I think that is the case. Mango Boulevard, Pty Ltd against Mio Art Pty Ltd, 218 QCA 39. Thank you. So section 18 of the Act provides that the parties are to be treated equally. The parties must be treated equally, and therefore they must be given an opportunity, a reasonable opportunity, to present their case. Section 19 provides that the rules of procedure are to be determined, as is the place of arbitration, which is section 20. One of the hallmarks of the arbitration proceedings, as opposed to litigation, in a court context, is the issue of confidentiality. So confidential information in relation to the arbitral proceedings is something that the parties must respect. They're not to disclose that information. And the decision there that I want you to have a look at initially was the case of Esso Australia against Plowman, 1995, 183 CLR 10. Sections 27E to 27I effectively reversed this position that was in the Esso decision. So the High Court in the Esso case determined that the privacy of an arbitral proceedings should be respected. Confidentiality was not an essential attribute. So the legislation, of course, now deals with that issue over and above the previous court decision. The arbitrator has an important function to play, but as we mentioned earlier, it is still subject to the control of the courts. So Section 34A of the Act allows for an appeal on a question of law arising out of the arbitral award, but it's only in limited circumstances and only on an opt-in basis. So therefore, we have the issue of potentially an appeal that may apply in certain circumstances based on a question of law. But again, coming back to that question of is there a right to appeal the award itself, the Mango Boulevard and Mio Art decision, Justice Jackson, now this is the earlier decision at the first instance. So the first decision that I mentioned today was the Court of Appeal decision, and I'm going to also refer you to the decision at first instance. So 2017 QSC 87. So Justice Jackson dealt with the matter at first instance, and then the matter went to the Court of Appeal. So His Honour's decision was last year, 2017, Court of Appeal this year. What I'd like you to do is have a look at paragraph 20 of the decision. And in that case, Justice Jackson adopted the words of the Chief Justice of Singapore, delivering a judgment to the Singapore Court of Appeal in a case called AKN and Another against ALC and Others, which is 2015 SGCA 63. I think this is the only case from Singapore that I refer to in the various units that I take. I'm just going to read it. This is what Justice Jackson adopted in the Mango Boulevard decision. In particular, there is no right of appeal from arbitral awards. That is not to say that the courts can never intervene. However, the grounds for curial intervention are narrowly circumscribed and generally concern process failures that are unfair and prejudice the parties, or instances where the tribunal has made a decision beyond the scope of the arbitration agreement. So again, we're getting that consistent theme of fairness and procedural fairness, prejudice, bias, if you like, and importantly, jurisdiction. Does the arbitrator have the power, the jurisdiction, to make the award that it does? Going back to the decision from Singapore, the court went on to say that it follows from the court's perspective that the parties to an arbitration do not have a right to a correct decision from the arbitral tribunal that can be vindicated by the court. Instead, they only have a right to a decision that is within the ambit of their consent to the dispute, and that is arrived at following a fair process. In light of their limited role of the arbitral proceedings, courts must resist the temptation to engage in what is substantially an appeal on the legal merits of the award, but which, through the ingenuity of counsel, might be disguised and presented as a challenge to procedural fairness. So do you see the distinction that I'm trying to draw? I think that the words used by His Honour in the decision at first instance are very important in showing you or demonstrating the way in which the arbitrator and the arbitral award works in conjunction with court process. It's available, but it's limited. Coming back to the legislation, have a look at section 34 of the Commercial Arbitration Act. It provides the only recourse for setting aside an award, and a challenge can be made by a party based on substantive or procedural mistake. So firstly, in terms of a substantive challenge, a party can successfully challenge an award made by an arbitral tribunal if it can show that the arbitral tribunal had no jurisdiction to hear the dispute. And that's pretty basic, isn't it? For example, if the arbitration agreement was void based on law of contract, or the tribunal was simply not empowered to hear the dispute. The second aspect, and this is in section 34, relates to procedural challenge. So the Act, the Commercial Arbitration Act, sets out procedures which require parties' compliance. The opportunity to challenge procedures in a court is limited because the arbitral tribunal is there to remedy certain matters, or the court is there to remedy certain matters, but not beyond that. So pursuant to section 34, subsection 4, the arbitral tribunal has an opportunity to fix its own procedural errors, and that's part of the process of trying to resolve matters quickly. So again, looking at the Mango Boulevard decision, and I'm talking now about the 2017 decision at first instance, where an applicant applied to set aside the awards under the Act, it was argued that the arbitrator rejected witnesses' evidence and made findings on the basis of points not raised by the witnesses or counsel, where the applicant argued the arbitrator acted in a procedurally unfair manner by finding costs that was outside the range of values advanced by the applicant and the respondent. And the question was whether the award should be set aside on that basis because of natural justice or procedural fairness issues. All right, so have a look at the Act, have a look at that case in particular, in both instances, first instance and in the Court of Appeal. Be prepared to argue in an assessment piece, if this is what happens, about the advantages and disadvantages of arbitration. Now, I know I've been doing a lot of talking, but I'm going to invite you to come up with some thoughts now, if I may, about the advantages and disadvantages of arbitration. Could we start with advantages? And you can use the chat facility, or you can unmute your microphone. I've got a list. We'll see if we have some common factors. So what are some of the advantages of arbitration as opposed to court proceedings? Confidentiality. Yep. Cost. I like both those things. We can come up with some more, can't we? Clients are in control of the result. I think they're in control of the ability, not necessarily the final result, that would be with the arbitrator, but I think certainly in control of the process, control of the ability to present their views and have some input as to the process, and of course the choice of the decision maker. Amanda says timeframes, and I think that's very important. So we're looking at something that is cost effective, something that is going to be quicker, it's confidential. The finality, that's a good one. I didn't have that. Yes, I did have a note to that effect, but that's a good one, Craig. The fact that it's final, the parties have agreed that this is going to be the end of the matter. That's important as well. I think in terms of advantages, we can look at some of the similarities with litigation, some of the positives of litigation, such as, for example, the ability to provide expert evidence to the third party decision maker. So you've got an arbitrator who's an expert, says Diane. So perhaps an expert in that field having some technical or experience available. So it is very, Marcus said private or confidential. Why would that be potentially important, do you think? And Anthony's joined us. Hi, Anthony. So why do you think that, yes? Hello. So why do we think that it's important that it's confidential? And I've used the word private. Can you imagine why clients would find that business? Yep. So Marcus says because of business. It may be that a large organisation is not particularly keen on information which is discussed within the context of the dispute having a wider audience. They might want to keep it in-house as much as possible. So I'm going to set you this exercise to think about the advantages and disadvantages of arbitration. So far we've been talking about the advantages. And the list that I've got here, which I think is great: confidential, cost, clients remain in control of the process, the time frames, finality, expert arbitrators, useful for keeping private information that might be business related. And Chris has come up with another one, which is very good, and that is it's a more flexible process. So I agree with all of those things. And maybe there'll be some more. Always, in answering a question of this type, it's useful to refer to 3 or 4 different things. One is legislation. Next is case law. It might be a quote. Another is information from textbooks and writings or articles generally. So if you can support these statements that you make with some degree of authority, so much the better. And Marcus says, and it's confidential for family matters as well. All right, so thank you for that list of advantages. What about disadvantages? Can you think of some things that are not so good about arbitration compared to litigation through the court system? Limited powers, says Craig, yes. Less control over the result, says Kate. Disadvantages of arbitration compared to curial determination. Enforcement, that's a good one. Limited appeal, yes. What about the type of dispute that we see in arbitration compared with the sorts of disputes that we see in court proceedings. Would you say that one is perhaps potentially broader than the other? Amanda's come up with a good one. No day in court. That's a fair comment. Although, of course, arbitration by its nature gives that impression of being a day in court. So that might be a good facsimile for parties that do want their day in court. So what about the type of disputes? And I guess the name of the legislation that deals primarily with arbitration gives a hint there. The Commercial Arbitration Act. So it would be, I think, fair to say that advantages for arbitration mostly relevant for commercial disputes. Commercial, says Amanda. B says it doesn't change or advance the law. And that's right. You can imagine a situation where 99% of litigation was determined by arbitration. We're not gaining that learning experience, are we? So as to better predict how matters might be resolved in the future. Do you think that there's, now whilst we mentioned that it's more cost effective, do you think that that might be relative to some clients, but relative to others, more cost expensive? Do you think that because given that the arbitrator is going to be appointed and paid for by the parties, there'd be many clients, wouldn't there, that would say, I can't afford arbitration. I can go to a court and I can represent myself for free. So whilst on the one hand, for those involved in commercial litigation that can be very expensive before a court, it might be very cost effective. For others, depending on the nature of the dispute and their personal circumstances, arbitration might be beyond their financial capabilities. So it's still an adversarial process. Potentially, arguably, there's limited scope for the monitor for the arbitrator to have what he or she does monitored. We've seen the difficulty in that the Mango Boulevard Mio Art decision. And Jackie said the Fair Work Commission arbitration has no cost if self-represented. Well, that's a good point. Thank you, Jackie. That's very good. So is the potential for lower penalties results in arbitration versus court? I'm not sure what that one means, Diane, sorry. We're talking about a prosecution type matter.
Like if you were going against a company and wanting financial compensation, would you potentially have higher result if you went to court as opposed to arbitration? I'm just curious.
Well, possibly, but it may go the other way. Okay. In that a defendant, knowing that the process is confidential, may not be so concerned about the precedent value or disadvantage of a high award. So they may be more inclined to settle quicker, even if it costs them a bit more. They don't have to fight tooth and nail. So it may go both ways, but that's a very good point.
Okay, thanks.
Right, thank you. I'm glad you raised that. I hadn't thought about that issue. Okay, so you understand what I'm getting at. It's an opportunity for you during the week to think about those advantages and disadvantages if you're in a situation of having to advise clients as to which way they should proceed. In terms of external resources, have a look at the Australian Centre for International Commercial Arbitration. The ACICA is independent. It's a not-for-profit organisation, and its role is to assist in the resolution of commercial disputes by arbitration and mediation. So that is the Australian Centre for International Commercial Arbitration. It is the sole default appointing authority competent to perform arbitration appointment functions under the International Arbitration Act, which is from 2011, which is when it commenced. Also, in the context of arbitration, have a look at the family law regulations. Have a look at Regulation 67B, which deals with family law arbitration. And Section 10, M of the Act, talks about a definition of an arbitrator, the prescribed requirements for an arbitrator. So in the Family Law Act, have a look at what is required for a person to be an arbitrator in that jurisdiction. Okay, all good? Let's move on then and start talking about some other dispute resolution processes, which is, if you like, the week 7 material, which correlates to chapters 5 and 6 of your text. Okay, we're going to deal with a few tonight. So the first is collaborative law. Has anyone had any involvement with collaborative law? Understand what it means? Usually we see collaborative law in a particular area of dispute practice. Does anyone know what that is? So what's collaborative law mostly involved? Okay, we're getting a few votes. Building, family, divorce, construction. I'm going to go, the one that comes to my mind is family. So I'd agree with Ainsley in that regard. It can work for other areas, but it's mostly, you'll find, I think, in family law situations. So collaborative law involves a group of firms, say 2 firms, making a pact, as it were, with each other and with their clients that they will not go to court and that they will attempt to resolve issues of concern through collaborative procedures, mediation in particular. And it's, if you like, the overriding way in which the dispute is resolved. So we tend to think of dispute resolution as discrete events, don't we? An arbitration or a mediation or a conciliation. Collaborative law is overarching, where it says we will embrace this dispute that you have and we will, through collaborative law process, attempt a matter, an ADR process or a number of processes on a one-off basis or over a period of time, but the ultimate aim is to stay out of court and to resolve the matter. So it may be that 2 parties consult separate collaborative law firms in a family law dispute. The process then is led by the lawyers, and they do act as advocates rather than co-mediators. They may start with an informal conference and a roundtable discussion, but with a twist, and the twist is we are not going to court. That's a given. It's almost like mediation without a mediator, but the parties can always consider mediation as well. So I'm talking about, if you like, the first round of collaborative or law practice, which might be this informal conference and roundtable discussions. The dispute is taken a little away from the parties in the sense that the collaborative law practitioners control that process, and part of what they might do is then engage a mediator to act as the ADR practitioner for that mediation session. So then the collaborative law practitioners are there as advocates. So if you're acting as a collaborative law practitioner, you're not acting as a mediator, you're not acting as a conciliator, but you are embracing the ADR concept overall. I hope that makes some sense. Does anyone have any comments, questions about collaborative law?
Hi, John.
Yes, Jackie?
Yeah, I was just going to say, last year I had the privilege of a 4-day conciliator conference with David Hoffman, who's the founding member of the Boston Law Collaborative, and he's an adjunct professor at Harvard. Their website gives a really good description of collaborative law. Obviously, it's in the States, but it's called the Boston Law Collaborative. If anybody wants to Google that, they'll get some information about collaborative law there.
Excellent. So that was the Boston Law Collaborative?
That's right, yeah.
Oh, great. Thank you very much, Jackie.
No worries.
And please feel free to add that into a U-Crew discussion, and I'd really like to advance that. So when you're thinking about collaborative law, particularly in the context of an assessment question, if it's on the assessment, is, where did collaborative law begin? Can you define it? What's its definition? What are the characteristics of collaborative law? As best you can, are there any steps? And Nicholas has got the website, blc.law. Thank you. So are there any steps in collaborative law process? I've indicated that there's not necessarily going to be a single set of steps, but can you create a flowchart or some steps? In what dispute area or areas works for collaborative law? Jackie, did the professor indicate any particular preference or parameters for where the type of disputes?
Oh, so he did discuss some of the work he did, but he was mainly there to mentor us in our processes. But he did just talk about, it is usually involving solicitors, and they get an agreement from all the parties at the start to agree to try and resolve the matter without litigation. That's the key focus for them.
So yes, so that common focus, I tend to think of it in terms of family law, but of course it has a wider breach than that. Thank you. So, and what do we make of collaborative law? Do we need it? Does it serve a purpose? And cynically, did lawyers create collaborative law to assist lawyers rather than participants, when they could see mediation, graining and momentum and thinking, we're going to get squeezed out here, so let's take on collaborative law so we control the process. Even if we go to mediation, we're still involved there as advocates. I don't know. There's no right or wrong answer to that. I'm just raising questions for you to consider in the context of collaborative law. So in Queensland, if you look for those lawyers who practice in collaborative law, I think you'll mostly find it comes out of family law practice. And the idea is that there's a commitment by the lawyers to withdraw if the matter does proceed to litigation, and there is a collaborative agreement made. So again, if you're looking for a definition about collaborative law, look to NADRAC, and NADRAC defined collaborative law in these terms, where the process is led by lawyers representing each of the participants, where it is agreed the lawyers will cease to act if the matter proceeds to litigation. That's pretty much simply it. The process is focused on collaboration, which means that the idea of the practice is for parties to look at the issues to solve the problem rather than to increase the problem. And it's interest-based negotiation rather than position-based negotiation. It involves a process where parties are to a degree led by their own lawyers, but the lawyers are not third-party neutral, which is a very different thing to what we've been discussing in other contexts. And the lawyers act in the interests of their own clients. They are not co-mediators in collaborative law. There is a collaborative agreement, and the lawyers in that will specify the rules, mostly importantly, as Jackie pointed out, that they won't go to court and litigate. But there are other things that they might do. So in collaborative law practice, the lawyers may decide to bring in third parties. I've mentioned one already, a mediator. And that mediation can be in one step or it can be a number of steps. But they may do other things. The collaborative law practitioners may say, in order to resolve this in a non-adversarial manner, in a cooperative manner, non-litigious, maybe we need other allied professionals to come in. So if, for example, you're involved in a family law dispute and you're now a collaborative law practitioner representing a client who is committed to the collaborative law process, can you think of perhaps some allied professionals that you might encourage to be brought into the process formally to assist the parties to resolve their disputes? Any thoughts? Accountant and counsellors. I like both those. So accountants, let's not argue about the finances until we've really narrowed down the facts. And by the parties working with their lawyers collaboratively with their expert, the accountant, we have a better idea of the true position rather than guesswork. It involves a lot of goodwill and honesty and open attitude towards a resolution. The other one that Bea mentioned was counsellors, which I think is excellent because lawyers are not trained to be counsellors, nor should we be counsellors. We may take on a counselling type role, but we should never become the counsellors. We're there as advocates to advance the interests of the client. But that's not to say that counsellors don't have a purpose, and by engaging counsellors, that may be a very useful addition to the team. What about just a coach? Like, bring in a coach who can support the parties, maybe even support the lawyers, or a mediator. So think about who you would bring in if you were a collaborative law expert in terms of third-party support. Now, of course, it's a voluntary process and it does require a lot of trust and cooperation and disclosure of information. Social workers, psychologists, others have said. Okay. Collaborative law steps. Now, if you were a collaborative law practitioner, the first thing you probably want to do is identify the interests of the parties as opposed to their positions. And one of the best ways to identify interests of parties is to think about their worst alternatives to a dispute, a negotiated dispute or agreement, and their best alternative to a negotiated agreement, the Watner and the Batner. Number 2, identify the questions that need to be answered. Number 3, gather information. Number 4, generate choice. Number 5, evaluate options. Number 6, negotiate an agreement and then close. So have a look at Spencer, page 171, where he talks about the background to this in the context of family law and this paradigm shift from adversarial to cooperative practice for some lawyers. The question is, do you think that collaborative law takes away the dispute from the clients, or does litigation take the dispute more away from the clients to a greater degree? I would have thought that collaborative law does to some degree take the dispute away from the clients individually, but empowers them to a much greater degree than would be the case in litigation. So I think that there are some real benefits. One of those is that it does help the parties in an ongoing situation. And this is why I think it's well suited to family law, particularly if there are parenting issues involved, in that there is going to be an ongoing relationship through the child or children. So having a collaborative approach minimises the damage and, in fact, to some slight degree, may heal some wounds and make life easier, more positive for people down the track. Let's move on to another one, dispute resolution advisors. Now, this is a process, often at a pre-contract level. On that sliding scale of 14 different types of ADR practice, it's number 3, so it's very much less interventionalist, so quite the opposite end of arbitration. So what do we mean? What do we make of being a dispute resolution advisor? When would that be relevant?
You try to prevent disputes from happening, especially when you know they're going to happen. Usually you would do that with very large commercial projects, which cost millions or billions of dollars.
Excellent. So often, when you're involved in a pre-contract level, in a commercial dispute in particular, discussing and possibly appointing a dispute resolution advisor is an important step. And it, as Bea said correctly, you're trying to preempt disputes that may occur down the track. You're setting up a mechanism right at the start that takes advantage of the skills of the advisor. The parties may not accept the decision that's made, but the process is intended to allow for, if you like, on-the-spot resolution. What are some of the criticisms of legal practice are that it takes too long to resolve the dispute. Well, if you involve a dispute resolution advisor, you're taking advantage of an advisor with technical skills who can speak with authority. You're also providing this ability to have an on-the-spot resolution. A dispute arises in the morning, we can have it resolved by the afternoon. We don't have to stop tools. We're not running off to get injunctions. The project, which is, as B said, typically a multi-million-dollar project, can march on and everybody can be on the job tomorrow, even though it's a big dispute. So it, again, is collaborative in this sense, in that by appointing a dispute resolution advisor, the parties are really acknowledging that they have to accept a collective acceptance of the problems, and they commit to a quick dispute resolution mechanism to be put in place. All right, so Nicholas says, Oil Code Dispute Resolution Advisor, appointed by the Commonwealth Minister for Resources and Energy to assist in resolution of dispute between distributors, wholesalers and retailers about the supply of motor fuel in Australia. Yes, I'm appointed in a sister and a nephew organisation of that, which is for mediation involving franchise. So the franchise mediation advisor. So it's related. It's all the same advisor's office. But no, that's a very good point, Nicholas. So what I'd like you to do is think about what's involved in dispute resolution advice practice. Would you, as an advisor, encourage clients going into a contract to think about this and put it in place? Could you see yourself being a dispute resolution advisor? Could you see yourself setting up practice in that type of field? Particularly relevant for those of you that have skills external to law. So when you're doing your preparation, think about where the concept began. What's the object of appointing a dispute resolution advisor? What's the process adopted by the advisor? And what's the role of an advisor compared with an appraiser or a referee? So they're different. But dispute resolution advisors were, in fact, as B pointed out, initially introduced in relation to large-scale contracts, government contracts in Hong Kong, and the parties were trying to resolve the issues quickly in that regard. So the object of a dispute resolution advisor is to work with the parties at a very early stage, and it's an opportunity to discover differences of opinion, differences of procedure, and one of the issues may be that as a result of resolving an issue at an early stage, it actually helps to prevent other issues and blow-ups down the track. So that simmering problem that ultimately might derail the whole project is something that can be worked upon early on. So usually the parties are involved with some experience, and the idea is to say, this is not your problem, or this is not my problem, this is our problem. That's kind of the approach that you want to foster with the parties. So just as a tip, given that the appointment of a dispute resolution advisor is intended to be a dispute avoidance process, it should be something that is considered and agreed upon by the parties at the pre-contract stage. The dispute resolution advisor can help the parties negotiate the contract for a project, or be appointed via the contract. So what I'm suggesting there is that even though you might think about building in the process in the contract to appoint a dispute resolution advisor, why not get the dispute resolution advisor involved at pre-contract to assist the parties in negotiating the terms of the contract, so that the advisor has some say in how the whole dispute resolution system might work. Just an idea. So have a look at page 151 and figure 5.1, which shows a dispute resolution advisor flowchart. It's merely an example. It was the one that was used for the refurbishment of the Queen Mary Hospital in Hong Kong. Contrast the role of a dispute resolution advisor to an appraiser or referee. So strictly, the appointment of a dispute resolution advisor is a dispute avoidance process rather than an alternative dispute resolution process, so ADR, but we think about within the same context. And the dispute resolution advisor does not seek to impose a solution on the parties like an adjudicator. So in that sense, it's less onerous, and it's not something that is imposed on the parties to the same degree. I'm going to wrap up early tonight, but what I'm going to invite you to do, and I'll do this now, is I want you to think about how you might use dispute resolution advisor in real context. Have a look at the NBN Co Special Access Undertaking and the approved dispute guidelines, and we'll start by looking at that next week. So what you'll see if you find this in the internet is a document that contains the dispute guidelines for NBN Co and the Special Access Undertaking, and there's some very useful precedents there. So I want you to have a look at that before we come back next week. And it's a worked example of how to use dispute resolution advisors in the context of anticipating and resolving disputes before they start. All right, are there any questions, comments? Okay, and beyond that, next week we'll be talking about dispute review boards, and what I'll do is I'll put some questions on UCrew and Moodle so that you've got some things to think about as we prepare for the next set of ADR processes. Okay, all good. On B's found it already. Thank you, B. So www.accc.gov.au, Regulated Infrastructure Communications National Broadband Network. That's it, the Special Access Undertaking. So have a good look at that, because there's some very good precedents. So if you have a question that revolves around this topic, that's a great place to look. Okay, then Craig's found some information as well. Please share information on UCrew. Do some preparation. I'll put up some questions for you to consider ready for the next session. So all the best, and I'll have those marks back to you within about 10 days. That's my aim anyway. All right, all the best, and we'll see you next time. Bye then.